The maximum security deposit a landlord can ask for in California is about to change. There is a new law, Assembly Bill 12, which takes into effect starting July 1, 2024. AB-12 states a rental property owner cannot demand or receive a security deposit in an amount that exceeds 1 month of rent. Exception? You are permitted to have up to 2 months' rent as security deposit if the landlord is a natural person or a limited liability company in which all members are natural persons, and the landlord owns no more than 2 residential rental properties that collectively include no more than 4 dwelling units offered for rent. For example, if you or one of your business partners in a property owns a duplex and a triplex, then you have 5 units and don't qualify for the exception. This exception does not apply when the tenant is an active service member. The maximum security deposit allowed for an active service member is always 1 month's rent without exception. Please remember that it is against the law to discriminate against an active service member because of this requirement. What about security deposits already held? The law only applies to new security deposits obtained after July 1, 2024. Any deposits lawfully obtained before Assembly Bill 12 goes into effect can remain as is. What about furnished properties? The law applies to furnished and unfurnished properties alike. There used to be a 3-month security deposit limit for furnished properties, but not anymore. Now, furnished and unfurnished are treated the same. What about pet deposits? A pet deposit is still a deposit and included in the 1 month or any other applicable limit. After all, a pet deposit is still just a deposit, but with a stipulation that it may only be used for damage caused by a pet. If there's ever a situation when you're collecting this kind of deposit, call it an additional deposit. Of course, the limits will still apply. We can discuss this more in another blog. Can you charge first and last month's rent? You can certainly charge the first month's rent up front. You have to. However, you cannot charge the last month's rent up front and hold it separate from the security deposit as rent. If you did, it would be considered part of the security deposit, yet you would be putting a stipulation on it that it could only be used for the last month's rent. It would also go towards the AB-12 limit. Long gone are the days of charging first and last month's rent plus security deposit up front in the state of California. Are there ways to work around the AB-12 limits? Every time a new law goes into effect, there are people with creative minds who naturally try to find ways around it. Although creativity is generally a good thing, we strongly recommend that you follow the law and use your creative energy more productively. Remember this, the security deposit is really the tenant's money. It is held in trust just in case something goes wrong. Professionally managed properties have security deposits held in non-interest-bearing trust accounts, which are subject to stringent Department of Real Estate rules. The only way the fund should ever ultimately end up going to the property owner is if the tenant owes unpaid rent. Otherwise, any money not returned would go to vendors who repair or clean the property. If you are a rental property owner holding deposits, it's important that you keep this in mind. How will AB-12 affect the rental market? AB-12 will only help speed up the trend towards lower security deposits. If you qualify for the exception of the 1 month limit and qualify for holding up to 2 months security deposit, you will still be in a market where most landlords will be limited to holding a maximum of 1 month's rent. Therefore, you will be at a competitive disadvantage if you try to hold more. Why would you do that? Well, maybe to accommodate someone with a greater than average credit risk? Well, a little extra deposit won't matter much if something really goes wrong. That higher move-in cost may be scaring away your most qualified tenants. So really, there's no point. In fact, we are seeing the larger, more sophisticated rental property owners with big apartment complexes and large portfolios ask for lower security deposits. Reduced deposit gives them the competitive advantage of a lower move-in requirement to the tenant. That way, they can fill vacancies faster and even potentially achieve higher rents. Bottom line, AB-12 will change the amount of security deposit a California can require to no more than 1 month's rent. There is an exception, allowing a maximum of 2 months' rent for landlords who are natural people owning no more than 2 residential rental properties with collectively no more than 4 units. This only applies to deposits taken after July 1, 2024. These rules are the same for furnished or unfurnished properties. There's no exception for pet deposits or last month's rent. Don't try to get around this law. You need to follow the law, and don't forget the deposit really belongs to the tenant. Most landlords will be asking for a maximum of 1 month, with many of the bigger ones asking for less. So don't put yourself at a competitive disadvantage. In addition, many local counties and cities have laws that supersede the state laws. For legal advice, especially regarding a specific situation, we recommend that you seek advice from an attorney specializing in landlord-tenant law in the local area where your property exists. Of course, at the Mike Dunfee Group, we would be happy to discuss any of your property management and real estate brokerage needs in the Long Beach, Los Angeles, and Orange County areas. We would be happy to help.